ladies and gentlemen. It is my pleasure to welcome everyone on this virtual platform. We would like to extend a special welcome for our speaker, Mr. T.S.Kanmani, who will be speaking on civil suits trials and procedures. We are excited to have you all here to participate in this very special meeting organized by Madras Presidency Lawyers Forum. We could not have pulled off this 15th virtual meeting without hard work and dedication of our MPLF team, who have worked tirelessly for all our meets. I hope that today's meet inspires the ideas and discussions that can bring about constructive and transforming changes in our fields. Thank you.
I'd like to introduce our speaker, Mr. Kanmani, who is a very good practitioner in the state of civil side. His field of practice is civil side, looking after the family court disaster and also consumer courts, and he also appears before the Madras High Court. He has a thorough knowledge on the field of civil practice, and I take the pleasure to introduce our speaker, Mr. Kanmani. And his senior is also a prominent person in the Madras High Court, who held the post as standing counsel for the Corporation of Chennai. And Mr. Kanmani had the opportunity of assisting his senior, Mr. Madi, in various fields of practice in the High Court as well as in the City Civil Court. And I have the pleasure to introduce once again Mr. Kanmani. Brother Kanmani, the floor is for yours.
Thank you, brother. Today we are going to see the civil trial portions. And before that, I wanted to thank the Madras Presidency Lawyer Forum to grant me this opportunity to be in this webinar for briefing the civil suits trial procedures. Before I'm getting into the actual portion of trial procedures, before that we will have an introduction part of the sum up of getting along with the suit procedures. Before filing a suit, if needed, we can give you a pre-trial notice. Subsequently, we can wait for the reply or response from the opponent person for a minimum 10 to 15 days according to exigency of the matter in which we are affected. We can issue a pre-trial notice. Moreover, in some cases, it is mandatory to issue pre-trial notice. In some cases, it is not so. After issuing the pre-trial notice, we can file a suit before the proper civil court. In filing the civil suit, we are having various jurisdiction aspects to be considered. In that, for filing the civil suits, first we have to see the jurisdiction aspects for filing the civil suits under monetary jurisdiction and the territorial jurisdiction, and then the place of the defendants where he resides. Accordingly, we can file the suits. Okay. Then subsequently, once we are filing the suits, the summons would be issued. Summons would be issued to the opponent party, from whom we need the redressal. Subsequently, once the summons has been served, first and foremost, the jurisdiction point on the defendant's jurisdiction point, why we are filing the jurisdiction, because for even after getting the orders, in various cases, the advocates are meeting out the practical difficulty in execution of that degree. Only to that extent, for the execution of degree effectively, we have to file the suit at the defendant's jurisdiction in certain cases. Subsequently, after filing the suits, the summons would be served according to there are various provisions for summons, and that summons once issued to the defendant, the defendant would be appearing before the court. Through in person or through the pleader. They are permitted. Subsequently, after appearance of the court, appearing before the court, the if the judicial officer thinks proper and fit, they may refer the matters to the counseling or mediation, alternate dispute redressal forum. It can be referred to the mediation, counseling, or arbitration, anyhow. Even it may be referred to the Lok Adalat. Now, being a normal advocate, we will know the National Lok Adalat is often organized by the Supreme Courts and the High Court level, and then district level courts. In that, if it is a fit case, we can refer the matter to the Lok Adalat on the behest of the parties of the suit, or otherwise, even the judicial officer, he may refer the matters, if it is proper, to the Lok Adalat forum. Then the matter, if it is settled, we can via media we can settle the issue. If it is settled, then the matter may be settled, and they will make the things in writing, and then they will sign the things before the local authorities. Generally, there will be a retired high court justice, and then one among the lawyers or two lawyers. Accordingly, there will be a quorum will be formed, consisting of 3 members. In that case, it would be the local maybe the matter may be settled, and then it would be taken to the back to the court, and then the award would be passed in the local. It would be passed by way of degree before the judicial order. It will be passed, which is non-appealable case, non-appealable suit, or non-appealable degree. Moreover, if the matter is not settled before the Lok Adalat authorities, then the matter would be sent to the court, back to the court. Then, if it not settled, then the normal procedure as per CPC, it would be taken into issue. Then subsequently, the defendant would be given a chance for filing written statement, in which they can defer all the things. In that, they can defer, they can file a written statement with all the averments, stating, denying all the averments, or otherwise, if it is acceptable, it might be according to the case by the defendant. Subsequently, once the written statement has been filed, issues will be framed. In the meantime, if there is any exigency or emergency, both the parties, both the plaintiff as well as the defendant, may prefer an interlocutory application. Generally, it would be called as IA. Interlocutory application would be filed before the court. So, after filing the interlocutory application, then the opponent party would be given the opportunity to file a counter. In that counter, once the counter has been filed, the interlocutory application will be decided. Once the interlocutory application has been decided, either they may go prefer an revision or an appeal according to the nature of the IA. Revision or appeal has been preferred before the appellate court or the appellate authority. Even some appeal has been filed before the appeal has been filed before the district court also. In that case, once the appeal has been filed before the appellate court, if the stay has been granted, the suit would be kept in abeyance. Subsequently, at once the completion of appeal, then the suit would be resumed. Otherwise, if there is no stay has been granted by the appellate court, in that case, the suit would be proceeded without subject to the outcome of the appealable order. Then, once the issues has been framed, then the trial work will be commenced. Trial means it is the very vital part of the suit which to be contested. The suit, the trial is consists of 3 portions. One is chief examination, cross examination, and then re-examination. Generally, advocates are used to get along with the chief examination and the cross examination, but if needed, we can get along even with the re-examination. At once the trial has been complete. Once the trial has been completed, both the parties of the plaintiff and also the defendant need to get along with their witness and documents, evidence, everything to be put into trial. Once the trial has been finalized, subsequently the um, arguments will be commenced. Once the arguments has been commenced, the plaintiff will be given first priority for getting along with the arguments, and then the different for counter arguments, and then subsequently judgment would be pronounced. This is the basis of the trial procedure before the trial court. Apart from that, in all aspects, even pre-trial notice, suits, written statement, and trial, in all the things, in all the things, there would be an uh, vital portions to be played by the vital portions to be played vital portions to be played um, by the advocate on behalf of the parties, because once the notice, the law of estoppel will be commenced. Once the notice has been initiated, once the notice has been initiated, you cannot approve and reprobate your own stand. So you have to get along with the actual position of your case from the day one onwards, because the pre-trial notice speaks about your intention of the parties. So once the intention of the party has been exposed to the other side, then at no point of time you cannot revert to that aversion, because averments, because once you have been exposed to your averments, then you cannot the law of estoppel will come into enforce. So you cannot take back your averments. So once the notice, from the date of issuance of notice, that notice speaks till the Supreme Court, because to that extent the framing of notice is so much important. So then suit, filing of suit is more important. Even in the filing of suit, all the amendments to be mentioned properly. Parties, the plaintiffs to be properly in framed. Plaintiffs must be properly included, and then defendants also likewise. The defendants also properly included by the plaintiff. Subsequently, the cause of action to be properly drafted. The drafting is much vital role to be played in the civil procedures. Moreover, once all the parts of the suit must be properly drafted by them. Likewise, with respect to the defendant, written statement, also similarly it is equivalent to the plaintiff's suit. It is with respect to the defendant, the written statement. Once a written statement also, even at the time of filing the suit itself, you need to mark the document, file the documents along with the suit. The documents to be filed along with the suit to establish your prima facie case before the court. Then only the suit would be numbered. Subsequently, accordingly, written statement, in even at the time of filing the written statement, you have to file the documents. Then only the court will consider, and framing of issues will be taken. Otherwise, after the trial work, if it is you can file the documents. There are provisions before in CPC. We can file the documents even after the commencement of trial work. Then subsequently it need to be perused. That is the thing which we are going to see. In the meantime, uh, if any of the party has been expired, then the law of abatement will be come into force. It speaks in order 22. The law of abatement has been elaborately, it has been described. In that, you have to abatement will come into picture at once the parties of the suit has been expired. At once the parties of the suit has been expired, the opponent party or the other parties, except if there are 4 plaintiffs, if one among the plaintiffs, other 3 plaintiffs must come with the come with the death, come with the facts to be produced before the judicial officer, how he has expired, and it has to be by way of memo or by way of petition under order 22. Subsequently, if the petition, even the advocate may file a petition to that extent, my client has been expired, because once the party has been expired, the law of abatement will come into picture after 30 days. After 30 days, and then along with the delay, further 60 days, we can file a petition for abatement. Petition for impleading the parties. And then otherwise, if it is exceeds that stipulated 90 days, then your suit becomes abatement. It has been abated. Likewise, if the plaintiffs, in case of partition suit, if the partition suit is between the generally between the brothers and sisters, in that case, if there are three plaintiffs, and two defendants, if the five members, among the five members, two plaintiffs may be settled or come to the come to the in line with the defendants. If so, we then how we can proceed with the plaintiff, how we can proceed with the suit. In that case, we are having a provision order 1 rule 9, which speaks about the striking of the parties and add to the parties. In that case, the plaintiffs would be strike down with respect to the two plaintiffs in the rank of plaintiff, and then they will be transferred to in the nature of defendants. In that case, we need to file a amendment petition before the court, and then we have to bring it on tune, as if the plaintiff who is running the case in tune. Then there is a provision for each and everything. There is a provision for each and everything under CPC. At no point of time, we no need to struggle. There is no provision for conducting the case. Moreover, if assuming, if the suit has been filed, the in reasonable reasons, in some reasonable reasons, which is taken by the learned judicial officer, trial court, the suit may be uncontested, or otherwise it can be given a lift without taking proper steps. In that case, the suit may be dismissed for default. In that case, order 9 rule 9 will be come into play, and then we can restore the suit which has been dismissed for default, if it is a proper reason has been if it is a proper reason. After the petition has been filed by the plaintiff, the defendant would be given an opportunity for filing the counter. Then it would be adjudged by the judicial officer. Then it would be come into picture. And then if the petition has been allowed, the plaintiff is allowed to continue with the suit from where it has been stopped. Subsequently, in the same way, if the party to the if the defendant has left the case unattended or without conducting his case properly, then he would be set ex parte. In that case, if the party if the defendant has been set ex parte, then then he would be having a chance of filing a petition under order 9 rule 7. If it is exceeds 30 days of the order 9 rule 7 will come into play. In that case, if likewise the plaintiff will be given a chance to file the counter, then it will be adjudged by the judicial officer. Then then the defendant will be given a prior then he will be given a chance to conduct the case. If at all ex parte, after an ex parte order, if the defendant is failed to if the defendant has failed to file a petition under order 9 rule 7, then the plaintiff will be given a chance for taking the ex parte evidence, and then ex parte degree will be passed. Once the ex parte degree has been passed, then even then the defendant will be a given chance for filing a petition under order 9 rule 13, which 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 will give you a chance for the defendant for filing a petition. Then the counter, as usual, counter will be filed by the plaintiff, and then petition will be allowed. In this way, for each and everything, there is a provision in the CPC for getting a chance to meet the ends of justice. At last, in toto, for all the behind all the enactment and the provisions of the CPC, only to ensure the ends of justice are to be met. Subsequently, if in case, moreover, we will come to the main portion, trial. Today we are getting along with the trial. We are dealing with the trial procedures in civil. In that case, we are given a we are having an provision in that we are having we will be given a chance by the court for adducing our evidence and along with the witnesses. In some cases, generally, even the advocates, some advocates used to think the trial will be commenced only by the plaintiff. There are some circumstances when the trial can be commenced even by the defendant. In some cases, when the defendant has accepted the averments of the plaint or suit, then there are additional points to be put in issue. Then in that cases, the defendant can approach the court for even he may be taken a chance for taking a trial at first rather than the plaintiff. There are ample of opportunities given to the parties of the suit for filing for taking the trial by the plaintiff or the defendant. Right to begin. Order 18 speaks about right to begin the taking of evidence. In that case, the plaintiff has a right to begin unless the defendant admits the facts alleged by the plaintiff and contends that either in point of law or on some additional facts alleged by the defendant, the plaintiff is not entitled to any part of the relief which he seeks, in which cases the defendant has a right to begin. In that case, the defendant may be given a chance for put forth his witness before the court, and then subsequently, after completion of the defense side witness, then the plaintiff will come into he will be given second chance. Likewise, even there is a right of even there is such a right has been ensured to the defendant for right to begin his evidence. Subsequent, order 18 rule 4 speaks about recording of evidence by commissioner. In that case, there are order 26. Order 26 speaks in volume. The commissioner, the advocate commissioner. Even before that, I will mention one thing. Section 75 of CPC giving a power to court to issue commission, to form a commission for any purpose. Even under 75, the court has a power to issue commissions to examine any person, to make any local investigation, to examine or adjust so and so. In the case of trial, even as per provision under section 75, the court can appoint an advocate commissioner for recording an evidence in some certain cases where the witnesses were unable to come before the court. In such cases, it can be entertained. even for that, the party has to party has to file a case before the judicial officer for getting permission for appointment of advisory commissioner, for getting him for recording evidence, or according to the nature of the position of the suit. Then there will be a chief examination. In trial, there are three portions, as earlier I said. There are chief examination, cross examination, and then re-examination. In the case, in the given case, in the case, the chief examination will be the chief examination will be conducted uh, um, uh, before amendment during 2002, only by way of oral evidence the chief examination will be admitted, and then it will be recorded. Subsequently, the chief examination, it is the contention of the plaintiff or the party who is deposing before the court. In that case, the contention can be summed up by way of an affidavit, and then it can be put forth, it can be filed before the court, and the same may be given to the other side. Same may be circulated to the opponent party, to his advocate, or to the opponent party itself. In that case, after receiving the copy of the chief examination, there will be an the proof affidavit. Subsequently, after receiving the proof affidavit, the court will get into the make the deponent to come into the box, and then it will be and then it will record the evidence given by him. Subsequently, after the chief examination is over, and then if there are documents to be marked, then the documents would be marked by the parties. Subsequently, after the documents has been marked by the parties, the cross examination will come into play. Once the cross examination has been commenced, the cross examination must be legible. Moreover, in Mary Kuti Koshi versus Hemalita Pushpakaran, in that case, 2018 5 Law Weekly 116 Madras, it is equivalent to 2018 6 CTC 598 Madras, in which it has been as per order 18 rule 5, it has been for filing proof affidavit for the oral chief examination. It has been for oral chief examination, it has been permitted, and it has been in that case law, they are dealing with that provision. Subsequently, after the chief examination is over, the cross examination would be commenced. Each and every normally the cross examination will be treated as no advocate as each and every advocate must treat the deponent who is coming to the box as a guest of the court. But whereas the chief examination, in chief examination, there are several advocates try to pressurize or tension the deponent who is getting into the box. At that time, at that times, the judicial officer may take into the shoes, get into the shoes of the things procedure which is going on in the court. Then he can restrict the questions which has been put to him. It might not be in such a harsh way. Since the deponent is a chief guest of the court, then even for that, there are provisions in Evidence Act ensuring the judicial officer who is a judicial officer judicial officer who can rescue the deponent, and he can stop the cross examination, and he can put the question in maligned way, or otherwise he can curtail some questions which must not be asked to the deponent. In section 165, section 165 of Evidence Act speaks about judges' power to put questions or or production or order of production. In that provision, there are here the judicial officer has been given enormous power to interfere with the cross examination, and he can put the question in to meet the justice. Moreover, if the judicial officer is intervening with the cross examination, or he is stalling the cross examination, he can make a note of that, even in the in that deponent, even in the exhibits, even in that cross examination which has been taken into, he can make a mark of it. Moreover, it can be the exorbitant power has been mentioned in there is a citation, state of Rajasthan versus Ani Alais Anif in AR 1997 SC, page number 1023. It is equivalent to 1997 6 SCC, page 162. In that case, he is having exorbitant power. Moreover, the judicial officer is empowered to make a self question for to meet the ends of justice. He can make a self question to meet the ends of justice. He can put the question to the deponent who is in the box. Accordingly, to meet the ends of justice, he can put the question, or in some cases there might be some question which is irrelevant to the case. In that case, the opponent advocate has put the question to the deponent. In that case, the judicial officer having the ample power to stall the opponent advocate from putting that question to the deponent. In that case, uh, from putting that question to the deponent. Subsequently, um, even beyond that scope, the opponent advocate is putting the question to the deponent. The parties may object for the same. In that case, along with the objection, the judicial officer can record that question and the answer for that, and then the parties who are objecting the question, for what reason it has been objected. Subsequently, there is no need for counter blast of the deponent, for counter blast of the opponent advocate who is putting that question. It would be considered at the time of passing the judicial order, or the passing of judgment and degree. Subsequently, there might be a given of a chance of re-examination. There might be given a chance of re-examination for re-examination if there is any ambiguity in cross-examination, or for need of any explanation. Then only the re-examination will be permitted at the discretionary power of the judicial officer. The deponent's advocate may seek for permission to re-examine the cross which has been taken on the day. Then that re-examination may be subsequently clarified by the deponent advocate and get by way of re-examination, and the same may be endorsed. Subsequently, these are the procedures which these are the procedures at the time of cross-examination or re-examination. Chief, cross, and re-examination. This is the trial. This is the stage of trial which has been concluded. After the trial is completed, then once the trial has been completed, the parties of the suit would be given a chance for oral arguments. Subsequently, after the oral arguments, there will be a written arguments. In this, I told already, the advocate commissioner would be appointed by the court. Then the advisory commissioner, the role of advisory commissioner, and then his powers is everything is equal to a court. Is equal to a judicial officer. Almost is equal to a judicial officer. Only he is an extended arm of the judicial officer. The advisory commissioner is an extended arm of the judicial officer, um, uh, which has been fully it has been described in order 26. Order 26, particularly in order 16, 16A, 17, and orders 26, rule 16, rule 16A, rule 17, and rule 18. In these rules, it has been in full. It has been given narrating the powers of the powers of the advisory commissioner, how we can how we can commence the um, uh, is the nature of job. Even in that, even in that, the judicial officer has given a warrant for the advocate commissioner for some stipulated reasons, for getting inventories or for any other reason. Now we are within with only with respect to the trial work. In this case, the power of the judicial officer for recording the evidence, then he will be sent from the court by way of an warrant would be issued to the advisory commissioner along with the returning date also. If it is the returning date has been affixed on the day he need to report to the court what has happened, what is the stage. Probably the advocate commissioner need to return the court along with the warrant in the script and letters of the in the script and letters of the warrant. Then he can, at once receiving the warrant, he need to issue notice to the parties. After issuing notice to the parties by fixing a date and time where he is going to take the evidence, probably on the different house or hospital, according to the case nature, he need to go to that particular place, and then he need to take the he need to take the deponents uh, deponents from the deponent after deposition from the deponent. After the deposition has been recorded, after the deposition has been recorded, even there also they can file by way of a proof affidavit to the advisory commissioner. Then after getting the proof affidavit, it will be circulated to the opponent party for cross examination. At once the cross examination has been commenced, at once the cross examination has been commenced, in the same way before the trial court, chief, cross, and re-examination. After the completion of re-examination, the deposition would be recorded by the advisory commissioner, and then it would be reported to the court on the date which has been fixed. If the advisory commissioner is unable to execute the warrant, then he need to seek time. He need to seek time from the court for extension of time for executing his warrant in its letter and script. Subsequently, in this once over, subsequently in this main issue, at the time of deposing, before the court, the deponent, the parties who is let in into the witness box must not give false evidence. Then if he is giving a false evidence, then he may be taken into soup by the judicial officer. At once he is coming to know that he has given a wrong he has given a false evidence or witness before the court. Then there is a separate provision, law of perjury can be come into existence, and then the deponent who has given a wrong evidence or witness before the judicial officer to mislead the court to without meeting the ends of justice, he will be taken into soup. Even for that, the the opposite party of the deponent may file a petition for law of perjury, or otherwise even the court may suo motu taken an action against the person if it is come to know that he has given a false evidence or false document before the court, and then he can be tried. He can be he can be referred to the local jurisdictional magistrate court for making an offense under law of perjury. Then he can be put into issue. He can be tried under 340 of CRPC, 340, 195 and 344 of CRPC, read with under section 193, from 193 to 200, according to the case and according to the nature of the offense has been committed by the deponent before the court. Once the deponent has given a false evidence or false witness, once the deponent has given a false witness or false evidence before the court, and then even he may even he may produce a fabricated document. Accordingly, section 193 to 200 of IPC will come into picture, and he will be taken into soap, and he might be even to the extent of imprisonment behind the bars. That is the nature and status of the court, on which it will ensure the trial to be clear. It will ensure the trial to be fair and just fair, and it need to meet the ends of justice. Subsequently, even the court has the rights. Even the court has the rights under section 153B of CPC. The place of trial to be deemed to be open court. In that case, the court may fix. After the amendment, it has become before the open court. There is something different. Before that, the court may fix before the open court, and even the court may direct the parties. You must not be within the premises at the time of taking the evidence, and the court may restrict the parties who is before the within the court hall. Even the interested witness must be sent out of the court, because once the witness has been once the interested witness is there at the time of taking the witness of other person, then he will be tuned or tutored on what basis and how the case is going on, what are the questions has been put in, and how it has been rebutted. Only to that extent the court has ample power to restrict the person whom to be inside the court hall at the time of recording the witness. Subsequently, there are few persons are exempted from personal appearance. There are few persons from personal appearance. In that, certain women, as per their customs and rights, even they may be exempted from appearing before the court. It is stated in section 132 of CPC. As per 132 of CPC, there are exemptions for the parties to appear before the court. Appear before the court. Appear before the court, and then some other persons like president, governor, ministry of cabinets, and ministries of legislatures are exempted from appearance of civil courts for adducing evidence before the court. And then even at the time of even the courts may fix the languages in which the languages to the deposition to be recorded. In that section 137 of CPC will come into role that subordinate courts must record the evidence, must record the deposition only in the local language. If the parties, if assuming all the parties are only open to English, then at that time the court may permit the parties to record the deposition in English. And then in some cases, if assuming the deposition has been recorded before the High Court, then we have no other go except to record the deposition only in English, because the language of the court is restricted with English. The language of High Court is restricted with English. The deposition will be recorded in English. Subsequently, after taking the printout of the deposition, it will be read to the deponent who has adduced the evidence. It will be read to him, and then after reading the deposition, if it is everything is it has been printed as per his intention and vision, then he can permitted to sign the deposition. Then only the deposition will come into close. If assuming he is telling that it is not so, then he can very well put forth before the court for for change of some mistake has been taken at the time of deposition. Then the judicial officer has ample power to rectify or change the thing which has been recorded at the time of deposition on the same day, at the time on the same day, with a reason, with the reason why it has been changed. It must be mentioned in the deposition itself, deposition paper itself. Only due to this reason the deposition has been changed to this effect, and then it has to be it will be admitted, then it will be admitted by the deponent. Moreover, in general view, we used to even the normal language, court language, we used to say trial court, and then it's an execution court, and then it's higher forum, high courts. But whereas even there are some procedures and provisions which has been entitled the trial execution court to take the evidence. In that case, section 47 of CPC, where the questions to be determined by the court for executing a degree. In that case, the court has ample power to take the the court has ample power to take the evidence even at the time of execution of the things, where only on some stipulation and condition, where the trial was not commenced before the trial court. In some cases it has been, some cases the issues has been framed on that point, but the trial issues has been framed on that point, but the at the time of judgment or degree, it will not be considered the the issue which has been taken. In the other time, the judgment debtors advocate can the judgment debtors advocate can file a petition under section 47 before the execution court for execution court for questions to be determined by the court for executing the degree. Subsequently, order 21 rule 46C has given a power to the execution court, while the garnishee has raised on any issue, where ascertainment of the quantum of the amount. Then even at that point of time, under order 21 rule 46C, the execution court has ample power. Execution court has ample power to testify or to to determine the trial of disputed questions. The disputed questions may be tried by the execution court. Execution court, even under order 21 rule 103 also, likely it has been giving the power for the execution court. Subsequently, the execution court has the ample power to try as per section 47 of CPC. Then even the higher courts, a high court is having the ample power. Even the appellate courts, even the appellate courts as having the powers for conducting the trial for conducting the trial in as per order 41 rule 25, where the appellate court even may frame issues, because the learned trial court judicial officer may in some cases may fail to frame an issue which ought to have framed. If it is not framed, if it is not framed in par with the issues, then the High Court has the power to frame an issue, and even the High Court, if it deems fit, if it is a small issue, if it is a small thing to be adjudicated, then the court may permit the court the trial may be conducted, or otherwise the or otherwise what to say, the High Court may return to the degree or judgment passed by the lower court. The same court may conduct the trial as we have said of earlier. Accordingly, then the trial court has conduct the trial accordingly. Subsequently, after 2005, if I'm not wrong, after 2005, the ADA code has been implemented, which is making the lessening the burden of the trial court. The ADA code has been implemented, where exclusive where exclusive trial alone will be conducted by the ADA court. The ad hoc court judicial officer will not be having an power to beyond the scope of trial. Even at once the trial has been closed, at once the trial has been closed, the bundle to be returned to the same court, returned to the same court, um, returned to the same court for further adjudication. Even if the party is not turned up before the court for adducing evidence after several opportunity has been given to him, then the witness would be closed. If the witness would be closed, the party then his advocate will file a reopen recall petition before the ad hoc court. It will not be adjudicated by the ad hoc court judicial officer, since then it will be remand back to the actual trial court where the case was originally conducted. Subsequently, sorry. Subsequently, the court may fix the court may fix the time stipulation for it may given a lenient time to the witness, where they must not misuse the lenience given by the judicial officer, and they have to depose the witness in accordance with law. Subsequently, the remand back of the remand back, I was already telling about remand back of the bundle from the High Court to the lower court. It has been clearly and clearly discussed in the citation. Kindly maybe note down. Rita Pandit and others versus Atul Pandit and others. Rita Pandit and others versus Atul Pandit and others. 2005, 3 CTC, page 25. One important thing to be mentioned right now. At the time of cross-examination, the proof of it would be produced before the court. After filing the proof affidavit, if the deponent has not turned up or subject himself for the cross-examination, then the witness will not be taken into consideration without subject to the cross-examination. Then the chief examination will be a part and parcel of the as an document record of the court itself, but it will not be considered as a deposition subject to after the trial has been went on with respect to that witness. With respect to that witness, it has been mentioned. It has been deeply discussed in Sudha Devi versus MP Narayanan. Sudha Devi versus MP Narayanan. AIR 1988 SC 1381, page number 1381. In that, affidavit is not witness unless it is put to cross-examination. Once the cross-examination has been conducted, then only the veracity of the witness or deposition adduced before the court will enlighten before the court. Unless or otherwise, it is piece of affidavit. It will not. The plaintiff has failed to. The defendant has failed to cross-examine the plaintiff witness. Then, then failure of cross-examination by the opponent deemed to be accepted. Once the cross-examination has been by the opponent, it was not failure of the opponent is deemed to be accepted. If the dependent who is failed to subject himself for the cross-examination, it will not be considered as a witness. It is considered as a affidavit alone. Whereas on the part of the opponent who is failed to cross-examine the deponent witness, then it seems or it's deemed to be the opponent has accepted the proof affidavit filed by the deponent in the examination box. To that extent, Sarwan Singh versus State of Punjab, it has dealt in this aspect. Sarwan Singh versus State of Punjab, 2003, Criminal Law Journal, page 21, SC. And another citation, kindly it may be noted down. Salem Advocate Bar Association, Tamil Nadu versus Union of India, and 2003, 1 SEC, page 49. And Amir Trading Corporation Limited versus Shopor G Data Processing Limited. In both the cases, the Supreme Court has elaborately discussed how the trial to be commenced after remand, how the trial to be commenced by the trial court, which covers under Order 18, Rule 4 and Rule 5. This I am concluding my this session. I think that I have given to my purview, I have given enough briefing. If there is anything, you can make a question to me.
Yeah, thank you. It was really a wonderful session, and you have impressed us upon all the areas.
Thank you, sir.
Hope,
thank you so much.
Nobody will have that much doubt.
Thank you, sir.
May I now request Untitled Chapter to give the impression, please.
Yeah, she is from Mumbai.
Good evening, everybody. I am from
Good evening.
Advocate T.S.Kanmani, practicing in Mumbai High Court. Because I started my career with trials in the trial courts. So it was nice to hear you, Mr. Kanmani. You
Thank
have
you.
really given us elaborate briefing, providing us even with the sections and rules which probably even we have never looked into. So it was a very good lecture.
Thank you.
And we must appreciate the efforts taken by MPLF for
Yeah,
bringing
sure.
us lecturers like you to enlighten the brother lawyers who are sitting at home. It's a very good lecture, very nicely delivered, and I wish you all the best, and may you have good health and a
Thank
good
you. Thank you.
and MPLF. Once again, a very good effort, and I really enjoy the lecture series being held by you consistently. Thank you.
Thank you, Anita, for your wonderful comments about Kanmani.
May I now request Mr. Arvind Subramanian to give the impression, please.
கண்மணி ரொம்ப நல்லா பேசுனீங்க. Thank you so much.
Thank you so much, sir. Thank you.
Thank you, Mr. Arvind.
Thank you so much.
May I now request Raswa Prakash to give the impression.
Yeah, good evening, everyone. It was a very wonderful session by our brother Kanmani. Yes,
Thank you, sir.
traversed from all the stages of the trial. jurisdiction, right from jurisdiction, travels all the aspects of trial, right from bringing the legal hairs on record, the abatement aspect, and recording of evidence, and as well as the punishment for in demanding the matter for fresh trial, as well as the citations, as well as the Salem Bar Association's case. That is the landmark case as far as the civil jurisdiction is civil case law, civil cases is concerned. And my brother Kanmani has touched that aspect also. And we enlighten our, in these types of sessions, our knowledge gets brushed up or enlightened, whatever we call. And thanks to Kanmani for the effort he has taken. He shows he has practiced not only before the trial court but as well as the appellate court, because only a person who has practiced in both the sides can explain the not only the provisions but as well as the stages. That is, I really appreciate Brother Kanmani's effort. I look forward for more such sessions from Brother Kanmani.
Thank you so much.
May I now request Mr. Ramesh Kuti to give the impression, please.
Very good evening to all and all.
Good evening, sir.
Brother Kanmani, I am really very much thankful to you for this wonderful and amazing session on this subject.
Thank you.
It was like waterfalls flowing without any blockage. See, I could feel like even a very successful practicing lawyer who is very successful in front of the court. When it comes to the matter of taking sessions or talking in a webinar, might find some difficulty in putting forth the provisions and the clauses one by one. You have done a wonderful job, and especially you have made me to recollect my college days where my professor, civil procedure court professor, he used to, without opening the book, he used to talk right from top to bottom. So you have done a very good job today, and I can very well feel your authority as well as the in-depth knowledge, not only on the subject as well as on the practical experience. It will normally come only when you have a very good and good practice, especially on the civil side. So I really thank you for the wonderful session.
It's my pleasure, sir. It's my pleasure.
And which you have really made the other civil lawyers to embrace their subject of the CPC. Thank you very much.
Kanmani to do more.
May I now request Priya Vel Murugan to give the impression, please. May I request Vijay Ganesh to give the impression, please.
I think Vijay Ganesh.
Kanmani கேக்குதுங்களா?
Thank you. இப்பதான் கேக்குது.
சூப்பர், சப்ஜெக்ட் எல்லாம் நல்லா வேஸ்டா கவர் பண்ணிருக்கீங்க. ரொம்ப பியூட்டிஃபுல்லா இருந்துச்சு.
Thank you Vijay Ganesh.
May I now request Brother Vignesh to give the impression.
I think Manikandan, you can add Gauri and K7.
May I now request
after Vignesh.
Yes, sir. I think Vignesh has sent wishes in the chat.
Okay, fine.
And it was a wonderful session. And one Reshma has also sent a message that the session was wonderful. Gauri to give the impression, please.
Yes, sir. Kanmani?
Yeah.
Hello?
Yeah, tell me, sir.
It's a very good session, but you have not covered under Order 37 suits. Because usually we are filing under Order 37 suits.
No, there is a separate session has been conducted previously.
Yes.
Now, only with respect to normal trial cases, only to that extent.
And today he has taken up only trial. The other session has been. Nallakandi, you are there. Next. K7.
So, Mr. Nallakanda. Mr. Nallakanda, please.
திருநெல்வேலி சார்.
சொல்லுங்க Nallakanda.
கேட்டது ரொம்ப அருமையா இருந்தது சார். தேங்க்யூ சார். ரொம்ப பிரயோஜனமாகவும் ரொம்ப வண்டர்ஃபுல் சார். தேங்க்யூ சார். நான் திருநெல்வேலி வள்ளியூர் பார் சார்.
ரொம்ப சந்தோஷம்.
தேங்க்யூ சார். Thank you.
Every week we send you.
There are so many participants throughout Tamil Nadu and beyond Tamil Nadu also. That shows the interest of the brethren to have the wonderful session here. Thank you, Brother Nalappan.
Thank you, sir.
I think Vignesh has come.
Sir, I've come, sir. I've come, sir.
Yes, Mr. Vignesh, your impression, please.
Yes.
Your
Sir,
impression.
this is really a very good show he has done today. Really, like going through all the provisions. Like CPC is such a wide topic that trying to give us as much as information possible in an hour is not that very easy task. And which he had done it probably maybe another 1 or 2 seconds he'll be able to give us little more inputs on like how.
Then what of time?
It was a good impression given by all the participants here. Thank you for the encouragement and support given by all the persons who are given the impression. Thank you so much. And our next session will be on 11th July by Mr. Arvind Subramanian on the topic of clinical trial. This is a wonderful topic, and I think all the participants will benefit large, since the entire topic will cover the practical aspects of our regular day in, day out of a profession. And
Yes.
Good evening, sir. I am Kalidasan, sir. Perjury 195 340.
Yeah.
That very good matter, sir. So in all cases, false cases, சூப்பரா பண்ணலான்ற விஷயத்தை அருமையா சொன்னீங்க சார்.
Sessions we will do more. Future Kanmani will do more sessions in Tamil.
Yes. Oh, vote of thanks we can go, I think.
yeah, may I now request Brother Suresh to give the vote of thanks.
Friends, we have to thank our speaker. Friends, we have to thank our speaker, Mr. T.S.Kanmani, to make this evening an informative one. And this session shows that how perfect knowledge he is having over that particular subject. We have to thank him. Thank you very much, sir.
Thank you, sir.
And our sincere and special thanks to our Madras Presidency Forum, which once again showed that and proved that the opportunities given to a skilled persons